Freedom of the press is similar to freedom of speech. Although the press was limited to printed material when the First Amendment was proposed, technology has added new ways to disseminate information, so related laws have been modified. As we mentioned, libel is a defamation of character in writing as well as in pictures, signs, film, and other communications. Public officials must meet higher standards than ordinary people to win a libel suit. In New York Times versus Sullivan in '64, Supreme Court held that actual malice must be involved for libel of a political or a public official to occur. This standard has since been widened to all public figures, which include public officials as well as celebrities, movie stars, others in the public limelight. In the 1970s, judges increasingly issued gag orders restricting publication of news about a trial or pretrial hearing to protect the accused's right to a fair trial. In Nebraska versus Stewart, Supreme Court ruled that a gag order had violated freedom of the press, but has since upheld gag orders in certain cases where publicity would be harmful to a trial. Films were once routinely censored, but in 1968, the court ruled that they could be banned only if proven to be obscene. Radio and TV broadcasting has the least First Amendment protection. In 1934, the Federal Communications Commission was established to regulate airwave frequencies and license their use, allowing it to impose rules and administer sanctions. Some language, such as dirty words, not allowed in broadcasts, even though it is not obscene. There's no explicit constitutional right to privacy, but it is an interpretation by the Supreme Court. The basis for this comes from the First, Third, Fourth, Fifth, and Ninth Amendments as established in 1965 in Griswold versus Connecticut. That's a case in which the court ruled that prohibiting the use of contraceptives violated the right to privacy. Historically, abortion was not considered a criminal offense until quickening, the first movement of the fetus, but by the mid-19th century, state laws became much more restrictive, and by 1973, performing an abortion at any point in the pregnancy was illegal in most states. In 1973, the court ruled in Roe versus Wade that governments could not totally prohibit abortions because this violates a woman's right to privacy. It ruled that government action was limited depending on the stage of the pregnancy. In the first trimester, states could only require that a physician perform the abortion. The second trimester, to protect the health of the mother, states could specify conditions under which the abortion could be performed. Third trimester, states could prohibit abortions. In later rulings, the court twice struck down requirements for counseling before abortions, but in 1992, it allowed these requirements, plus 24-hour waiting periods, parental or judicial permission for minors, and bans on government funds for performing abortions. The abortion controversy continues today. Anti-abortion forces continue to push for laws banning abortion. In 1994, the Freedom of Access to Clinic Entrances Act banned protesters from blocking entrances to abortion clinics. In recent years, opponents have focused on state ballot initiatives to restrict abortion, laying the groundwork for a challenge to Roe versus Wade. But defeats in Colorado, South Dakota have proven this strategy unsuccessful. In 2000, Supreme Court invalidated a Nebraska law that banned partial birth abortions, a second trimester procedure. But in 2000, legislation similar to Nebraska's was passed in the law by Congress, and in 2007, the court upheld this law, reversing its previous position. The first highly publicized right to die case involving Karen Ann Quinlan, New Jersey Supreme Court in 1976 ruled that patients or their families had a right to refuse treatment. In Cruzan versus Missouri, Supreme Court decided that a patient's life support could be withdrawn at the request of a family member, but only with clear and convincing evidence that the patient did not want the treatment. And what if there's no living will? These rulings have led to the popularity of living wills. In the Terry Schiavo case in Florida, it was determined that for married persons, the spouse is the relative with authority in this matter. Florida legislature then passed a law allowing the governor to overrule the court. State Supreme Court said that law was unconstitutional. Courts also have historically upheld state laws prohibiting physician-assisted suicide. In 1996, in Washington versus Glucksberg, Supreme Court said that the Constitution does not include a right to commit suicide, assisted or not, but left the decision on permitting this practice to the states. Since then, Oregon, Washington, and Montana have legalized physician-assisted suicide. Privacy rights have taken on particular importance since the terrorist attacks of September 11th. Anti-terrorist legislation has eroded certain basic rights, including Fourth Amendment protections against unreasonable searches and seizures. One issue involves legislation authorizing roving wiretaps. A person under suspicion can be monitored electronically. A U.S. Patriot Act, enacted in October 2001, eased restrictions on the government's ability to investigate and arrest suspected terrorists. For the first time in history, it allowed the government to open a suspect's mail. Also expand its ability to search a suspect's home and monitor a suspect's online activities, phone conversations, financial records, and book purchases. And shortly after September 11, 2001, secret surveillance and monitoring, including wiretaps obtained without warrants, was allowed for the National Security Agency through an executive order. 4 years later, the secret program was reported by the media and criticized by civil liberties groups. In 2007, Congress passed a law that authorized these warrantless NSA wiretaps. Terrorist attacks of September 11th also strengthened the belief that civil liberties of non-citizens should be limited. The Bill of Rights does not state that its protections are limited to citizens, but the 14th Amendment does say all persons shall enjoy due process of law. Illegal immigrants are subject to deportation, but in 1903 the court ruled that this could only occur after a hearing. Despite the wording of the 14th Amendment, the courts have often ruled that non-citizens cannot make constitutional claims. Laws passed in 1996 allowed for deportation without court review or based on secret evidence. In Reno versus American Arab Anti-Discrimination Committee, the court ruled that non-citizens, even permanent residents with green cards, have no right to object to deportation. Finally, the Constitution prohibits ex post facto laws, those that would punish acts that were not illegal when they were committed. Under the 1996 laws, this does not apply to non-citizens. So what we have is a great balancing act between the rights of the accused and the rights of society. If the government accuses an individual of committing a crime, the individual is presumed to be innocent until proven guilty. The accused is allowed specific rights and may be set free on a legal technicality related to their violation. Some of the rights of the accused include limits on conduct of police officers and prosecutors, no unreasonable or unwarranted search or seizures, no arrest except on probable cause, no coerced confessions, no entrapment. The accused must be informed of their rights at the time of trial. And the defendant has pre-trial rights, prompt arraignment, legal counsel, reasonable bail, to be informed of charges, the right to remain silent. And at the trial, they have rights such as speedy and public jury trial, impartial jury representing a cross-section of the community, a trial atmosphere free of prejudice, fear, and outside interference, no compulsory self-incrimination, adequate counsel, no cruel or unusual punishment, the right to appeal their conviction, and no double jeopardy. They can't be tried on the same charge twice. Rights of the accused were extended during the 1960s Actions of police and prosecutors were limited while the rights of the accused were expanded, including the right to an attorney if the accused cannot afford one. That's the Gideon case. In Miranda, one of the more well-known cases, requires that police officers inform suspects at the time of their arrest of their right to remain silent and right to an attorney. The court spelled out the now familiar wording of a typical Miranda rights statement. The exclusionary rule, since 1914, the judicial policy called the exclusionary rule prohibits the admission at trial of illegally seized evidence. This includes evidence obtained in violation of Miranda rights or the 14th Amendment, which protects against an unreasonable search and seizure and requires a search warrant. It was later extended to the states. In recent years, the court has created some exceptions. Examples, when evidence would have been acquired anyway, or when an arrest is made in good faith. That concludes the lecture presentation for this chapter. Please check under course documents for additional assignments for this chapter.